Welcome to Casa Academy, Chapter 5, Part 9, where we will cover real estate brokerage activities and procedures. So, resuming in on one of the most high-stakes situations you're going to face as a broker acting as an escrow agent, we're talking about handling tricky, contested escrow disputes. When money is on the line and tempers are flaring, knowing exactly what steps to take is literally the difference between being a prepared professional and landing yourself in some serious legal hot water. Let's get right into it. Here's a quick look at our agenda for today. We're covering 1. Defining disputes, 2. FREC timelines, 3. Meal procedures, 4. Litigation types, and finally 5. Rule exceptions. If you're gearing up for that pre-license exam, memorizing these procedures is an absolute must. Section 1. Defining an escrow dispute. Before we dig into the heavy legal theory, let's take this out of the textbook and see what a dispute actually looks like out there in the real world. Picture this relatable scenario. You've got a buyer who is absolutely thrilled, all set to close on their property. But then, literally 2 days before closing, total disaster strikes. Their mortgage loan gets denied. Naturally, the buyer turns right around and demands their earnest money deposit back. But hang on, the seller looks at this situation and says, "Absolutely not. I took my property off the market for weeks for you. I'm keeping that deposit as compensation." So the million-dollar question is, who actually gets the money?
Well, that exact headache perfectly illustrates our formal definition. An escrow dispute happens when two or more parties make conflicting claims to the exact same escrow funds, and there's absolutely no mutual agreement on who gets the cash. Since both our buyer and our seller are fiercely demanding those same funds, boom, you've got a formal legal dispute on your hands. That money is essentially locked in limbo.
Now, what's really fascinating here is that how this whole mess gets handled entirely depends on who is holding the funds. If the money is sitting with a title company or an attorney, they generally operate under their own distinct rules. In most cases, they'll just cross their arms, refuse to release a single dime, and wait for the buyer and seller to work it out and sign a written release. But if you, as a real estate broker, are holding those funds, the rules change dramatically. You cannot just sit back and chill. Under Chapter 475 of the Florida statutes, you are legally mandated to proactively follow some incredibly strict procedures. Section 2, FREC notification and timelines. This brings us right to the chronological legal steps you have to take to solve this escrow problem. And let me tell you, timing here is absolutely everything. You need to burn this specific timeline into your memory for the exam. Day 0 is the exact moment you receive that last conflicting demand. The clock starts ticking right then and there. Your first requirement? You have exactly 15 business days, not a month, not just whenever you get around to it, but 15 business days to formally notify the Florida Real Estate Commission, or FREC, about the dispute. But don't relax yet, because the clock is still ticking for your second requirement. Within 30 days of receiving that last demand, you must initiate a settlement procedure. Really notice the difference there. 15 business days to notify them, but 30 total days to actually kick off a settlement. Section 3, the meal settlement procedures. So what exactly are these settlement procedures you have 30 days to start? Let's break them down. This is where a super handy memory aid comes in. Whenever you're staring down an escrow dispute, just think of the word meal. The 4 authorized procedures are mediation, escrow disbursement order, arbitration, and litigation. And as you're taking notes on this, your verification code is 699985. Make sure you really memorize this meal acronym because you're going to need it to quickly recall your 4 legal avenues on test day. Let's see what each of these letters actually means in practice. Let's look at the M and the A first, mediation versus arbitration. If everyone's willing to talk, they can start with mediation. This brings in a neutral third-party mediator to help smooth things out and hopefully reach a voluntary settlement. But here is the catch. That mediator has absolutely zero authority to make a binding decision. If the parties just can't agree and the whole thing isn't resolved within 90 days, you as the broker have to pivot to a different procedure. Now compare that to arbitration. This usually kicks in when everyone has already agreed in writing beforehand to use it. An arbitrator comes in, reviews the evidence from both sides, and then makes a binding decision on who gets the funds. Unlike mediation, an arbitration decision actually has teeth. It can be fully enforced through the courts. Next up, we have the E in meal, which stands for escrow disbursement order, commonly known as an EDO. Heads up, this is heavily tested on the licensing exam. An EDO is a formal request you send straight to FREC, asking them for official legal guidance on how to properly dish out those disputed funds. So, say you submit escrow dispute file number 547741 over to the commission. FREC takes that file, thoroughly scrubs through all the specific contract details and issues an escrow disbursement order that legally directs you on exactly how to distribute that money. It takes the guesswork completely off your plate.
Section 4. Litigation Court Actions Explained. But what if mediation fails? Nobody agreed to arbitration, and an EDO just isn't the right fit. That leaves us with the L in meal: litigation. When the parties are entirely deadlocked and have to go to court, the broker uses one of two very specific legal actions. The first is called a bill of interpleader. You use this when you, as the broker, are making zero claims to the escrow funds yourself. You essentially just want to hand the money over to the registry of the court, wash your hands of the whole mess, and let the judge figure out who gets it. The second action is a declaratory decree. You use this one when you actually do claim a legal interest in those disputed funds. Like, let's say your listing agreement clearly states you get a cut of any liquidated damages awarded to the seller. In that scenario, you seek a declaratory decree so the judge can sort out not just the buyer and seller's rights, but your financial rights too. Section 5. 3 crucial dispute exceptions. Okay, so we've spent all this time on the strict rules, but like a lot of things in real estate law, there are a few specific times when you get to bypass these normal procedures entirely. There are exactly 3 highly specific exceptions where standard Chapter 475 procedures do not apply, meaning you can just return the deposit without ever getting FREC involved. Number 1, condominium resales. Florida law actually gives buyers of resale condos a strict grace period to review the documents. If they officially cancel within that window, you just return the money. Number 2, financing contingencies. If the contract is completely dependent on the buyer securing a loan, and despite trying their absolute best, the financing falls through within the agreed time frame, you can hand back their deposit. And lastly, number 3, HUD purchases. When a buyer contracts to buy a property directly from HUD, HUD's own rules trump everything else. You just release the funds according to their provisions and leave FREC completely out of it. Section 6. Conclusion and key takeaways. We've covered a tremendous amount of ground in this explainer today. Let's quickly wrap up the core procedural arcs and timelines you really need to take away. I want to leave you with one final crucial question to think about. Why must brokers never, ever act as judges themselves in an escrow dispute? Well, the answer is simple: because it is not your money and it is not your role. Florida law lays out these strict 15 and 30-day timelines, and those MEL procedures, mediation, escrow disbursement order, arbitration, and litigation, specifically to protect everyone involved. These statutes are in place to make absolutely sure funds are handled properly and to stop brokers from improperly playing judge and jury. So next time you're holding an escrow deposit and a fight breaks out, remember this: rely on the procedures, watch those timelines like a hawk, and never try to make the final call yourself. Thank you so much for joining me for this explainer, and keep studying hard.